SJC-10849, Commonwealth versus Jose Torres.
Thank you.
Yes, Counsel.
Good morning. Emmanuel Howard for Jose Torres. Jose Torres is now 32 years old. He was arrested in 2008 in March. He's been in jail ever since. He was convicted of first-degree murder, and there's a strong likelihood that he did not commit the crime. And let me talk about 2 and 1. There were 5 issues that we brought in the motion for new trial with supporting documents and supporting affidavits. If the trial counsel brought in available evidence on 2 of them, the trial would have been different, and there's a strong likelihood that Jose Torres would have been acquitted. The other 2 that I mentioned in the motion for new trial shouldn't have been allowed to come in, but even if they did, they would have had less of an impact had the first 2 issues been introduced properly. And the last one, concerning the manslaughter instructions and the manslaughter argument, that wouldn't have even been necessary. So what are the first 2 items? We know from Dr. Stewart's review of the materials that I sent him, and they're detailed in my affidavit and his affidavit, that, in his opinion, there's a strong, substantial probability that the incision on the decedent's neck was done by an assailant who was left-handed, standing behind the victim. The victim's name was Melissa Santiago. She was 29 years old, a mother of 4 young children.
Wasn't there also evidence that the defendant couldn't use he's right-handed, or he's right-handed, correct?
He is right-handed.
But couldn't use that hand?
No.
There's no evidence of trial of that?
No, because he had a left clavicle operation, and there was no evidence that he couldn't use his hand. In fact, he says in his affidavit, I do everything with my right hand, throwing a ball, sawing wood, opening a can, doing all kinds of things with his right hand. His mother says the same thing. His sister says the same thing. He's right-handed, a natural right-hander. Now, I had proposed, and we have an affidavit from a upper extremity expert, Ms. Lacroix.
Well, Counsel, what do you say about the statements that the children made?
I say the statements that the children made, Your Honor, were confusing. And,
Jose hit mommy.
well, Jose hit mommy.
That's not
and-
confusing.
Yes, well, I'll tell you, they heard also from the children.
Yes, and one said he hit her with the chair.
Yep, and then we said, Daniel testified at trial. He was the younger of the 2 sons, and he testified at trial. And the question is, with this other evidence, would the jury then say, did Daniel make a mistake, or were the children confused? Now, Daniel said on the stand, after saying other things, he said in response to questions about Jose, we don't know him. and Jose never spent the night in the apartment. And Daniel denied that Jose ever lived with him or spent time in the household or was there that night or that he ever called Jose anything but Jose or that Jose ever cooked for him. Now, that's equivalent.
Jose had been living with them for what, 3 weeks?
3 weeks.
Yeah.
Yeah, right. Well, this is a 6-year-old. So he's 6 years old now when he's testifying. And again, we'll go back. The cases, at least there's a simple statement in a case called In Fields. It's a 800 P. Second, 862, and I mentioned in my brief, that talks about what the defendant has to show in a situation like in the instant case, where the petitioner must show us that what the trial would have been like had he competently been represented. So we can compare that with what the trial what actually occurred in the trial and determine whether it's reasonably probable that the result would have been different. In other words, enough to undermine the confidence in the outcome. Now, what happens is that when there was no competing evidence at the trial, no defense witnesses, they heard from the defendant vicariously through a recording that was made by the police when they interrogated him, and they had a copy of the transcript of that. So this is what they heard. They had the victim's DNA, so-called from red blood stains, and droplets on the duffel bag and items of his clothing. They had a foot mark on the floor that could have been made by one of his sandals, and that's one of the issues that we raised in the motion for new trial. There was atmospherics, such as the defendant visiting Ms. Pagano on Sunday, the Sunday morning on March 9th. To her surprise, he'd never done that before, and then later holding his head in his hands when he heard that Ms. Santiago was dead. They heard from him via the police interrogation that he might be an explosive person. They heard from her 2 young boys again, what they told the police and what they told the EMT. They heard from Daniel on the stand, as we just discussed. They heard from Ms. Serrano that she had to lie to him. She had to lie to Mr. Torres in order for him to come back to her house. She told him that her father wanted him, because if she didn't lie, he wouldn't come back. That should have been stricken. That was inadmissible. It's a prediction, a lay opinion of prediction of future conduct of the defendant, and it hurt him, and it displayed consciousness of guilt. Now, they also heard, then after all of that, they heard that his counsel, who had tried this case like Mr. Torres didn't do this, in the last seconds of his closing argument, he says, he says, well, you know, he didn't kill her, but the most that the Commonwealth could prove was manslaughter. And then the judge exacerbated that by giving confusing instructions. So then the jurors might say to themselves, well, this guy is on skids, he's in a casket, let's put on the lid. There's no competing evidence. If they had this competing evidence about a person with the qualifications of Dr. Stewart saying there's a strong likelihood that the person who did the incision was left-handed and did it from behind, and there was further evidence about his upper extremity capacities, and we tried to get the judge to approve that, and she dismissed the entire motion summarily for reasons stated in the Commonwealth's opposition, which I've spent a long time in the brief debunking, I will say kindly. But on that hand, we tried to go even further and say, look, he says he's right-handed, his mother says he's right-handed, sister says he's right-handed. You know that a right-handed person will do all of these things instinctively using, or a person would use his dominant hand on most of these things.
Now, help me understand, this was a slashing of the throat?
Strangulation first.
Right.
She's dead. Then supposedly the assailant took a knife and slashed her throat.
And any measure of the force used? I mean, in terms of what was cut?
Yes,
What was
very detailed.
What was cut?
The trachea, there's a 5 1/4 inch by 1 inch deep. That's, you can actually see, bad copies of the photographs that I sent to Dr. Stewart that are in the appendix, but there's a drawing also in the appendix, and I'll get to the drawing in a minute. Appendix, page 182. There's a 5 1/4 inch long incision. The depth is 1 inch. It's at the certain point where she marked, where this is Dr. Hull, the ME.
Right, so it's only 1 inch thick, 1 inch deep.
1 inch deep, enough to cut the trachea.
Okay, and now, in a moment, the Commonwealth is going to come up and they're going to tell us, I gather, that he had had previous injuries to his right hand, and that it makes perfect sense, given the injuries he suffered to his right hand, that he would use his left.
Well, he had injuries to his right hand, but they were minor injuries. He had a left clavicle fracture at age 13.
So,
And
so I had a
how old
I had a
was he?
clavicle fracture when I
he's-
was
he's-
8, but
he was-
I
I'm
recovered
sorry.
pretty quickly.
Well, what I'm saying is, that he says that he and 3 others say that he's right-handed and he used his right hand. I'm saying, I'm putting my money where my mouth is. Let Ms. Lacroix evaluate his capabilities and decide what he does. The chance, he does, nobody says he can't use his right hand, except the Commonwealth, for some reason, says that he can't use his right hand. Of course he can use his right hand. He says it, and we're willing to try to get to prove it.
When
But
he
there's
says,
no-
excuse me,
excuse me.
in a statement that he gives to the police, he basically says how he can't grasp things.
I can't grasp things. I can't grasp things with what? This is a question of weight.
And he says, anytime I try to grasp something hard, all I feel is a pain and it goes straight numb because you can feel the bone right here. I don't do much lifting. I can't exercise. I mean, like I said.
Yeah, the bone
So
he's
is-
talking about is his clavicle.
So you say he's talking about this operation he had right here. They had attached a ligament. You're saying that that goes to the left clavicle? That
It's
the,
in
ligament?
the records that I submitted, Your Honor. Here's a radial. It's very clear. There are several pages of it, but look at R245, a radiology report. There is a completely separated fracture in the midshaft to the left clavicle with distal fragment lying inferior. There is I can't read the centimeters, something centimeters of overriding. There's also suspicion of a non-displaced fracture at the base of the carotid process.
What page was that in the record?
This is 245, Your Honor.
That doesn't say anything about having a ligament reattached.
I'm sorry?
That doesn't say anything about having a ligament reattached.
Well, let me put it this way. Connected to the other thing, connected to the other thing.
Yes, well,
There-
that's,
This is a song
that's
about
certainly
it.
true.
Well, exactly, exactly. I mean, this is, if anybody has had a shoulder injury or dropped down, let's say it fell down and had this clavicle, part of the clavicle involved. If anybody has, one would know, and I have many times, not bragging, but football and other places, it hurts to raise the arm. And then, I hate to say this, but arthritis sets in. And arthritis can go on forever. I would point you to a wrist that happened when I was about age 13 also, and it still hurts at certain times. It limits. It limits. So I'm just saying, he had accidents to his right hand, slicing this, that, and the other thing. He had accidents to his left hand, too, when he was slicing slicing a tomato, and he sliced off a little part of his finger.
Was it clear from the record that the cut to the throat was from behind? Did it have to have been from behind?
Doc, have to, you're talking about 100%? Not 100%.
So it could have been from the front.
But if you look at it, and literally and figuratively, that's so awkward to do this in front. It's unbelievable. You have to practice to get something in that power, in that stroke, and in that depth, because you're pointing the point of the knife straight through, and you don't have the leverage that one would have in the back to dissect the trachea and go.
Does this assume she's still standing rather than having been strangled already?
sorry?
Does this assume that she's standing rather than previously already had a cord around her neck and lying on the floor face up?
She could be, no, because she was found face down.
Well, at one
That-
point, could she have
Well,
been face up and then?
she could have been. And
Okay.
I wasn't
just
there,
wanna
you
know-
weren't there, nobody was there. I'm telling you,
I'm actually asking what the evidence says about.
well, the evidence shows,
The sequence of the events.
the
Is
sequence
this the
is
last
this.
event?
The sequence is this: strangulation,
Right.
throat cutting. She's found face down in the kitchen table. There are pictures, and I'll refer you to, you can call up the exhibits.
And you're saying you can't cut the front when she's lying face down? So
Yeah,
she had to
well,
have been
that's one
standing
thing.
up when
What's
she was
that?
already strangled?
Well, if she's strangled, you can call, we can talk entire day about scenarios.
Was she strangled from the front or from the, was the person who strangled her behind her or in front of her? Does the record indicate
No,
that?
record doesn't show.
So she could have been strangled from the front and her throat
Could have
slit from the
been-
front.
She could have been strangled from the front, but there was a electrical cord used also around the neck. So there were 3 ligatures, and they were at different parts, as that drawing shows that I spoke about earlier. There are 3 ligatures, but whatever the time sequence was, she was strangled first. Then somebody did the slaying. Now, the slitting. Now we can go back to I told you 2, 2, and 2. Now we go back to the second thing. There was a sequence that was not put in front of the jury by the trial counsel, which should have been put through. And that is, there was an inconsistency about the Commonwealth's timeline. The timeline was that at 9:30 to 10, Ms. Fuller, who was the first floor neighbor, came up to the 3rd floor where the victim and the defendant lived, and the victim wanted some cocaine, a 20-pack, a 20.
Mr. Howard, I just want to point out you have a minute left.
All right.
So you want to summarize?
I'm going to
your-
summarize. If the thread of this is that there was one of the things that the boy said was there was a big knock. Jose threw down the kitchen table. Ms. Fuller heard a thud. She heard the thud between 2 and 3 a.m. Sunday morning. Mr. Torres' Charlie card was registered entering a Ashmont to through Dudley bus to Ruggles at 11:33. He also, and that's also in the appendix.
Mr.
Also,
Howard, your time is up. Please, you can finish your sentence.
yes, thank you. Thank you very much. There was a 1202 stamping of a 7-Eleven purchase at the corner of 1747 Washington Street near Mass Ave. And so he was supposed to have left already on his way to see his father at San Juan Street. And the thud was, but the thud was 2.5 to 3 hours later. That's
We'll
the
have to
second.
leave it there, Mr.
Thank you.
Howard. Thank you.
Good morning, Your Honors. If it please the Court, Donna Padalano on behalf of the Commonwealth. And sitting with me at council table is trial prosecutor David Deacon. This is a case where the defendant simply did not meet his burden in the motion for new trial to show ineffective assistance of counsel. When you talk about the record evidence about his ability, his handedness, whether he was right-handed or left-handed, whether he had strength in those hands. First of all, the most important thing is Dr. Hull said you couldn't even tell which way the incision had been made, whether it had been made from the left going to the right or vice versa.
But the expert that the defendant proposes says you can do that. That in fact that it is not roughly horizontal, no, but that it is higher at one end than it is at the other. So there's a difference between what the two experts see.
Well, first of all, Dr. Hull wasn't testifying as an expert about that. That was just part of her testimony about the autopsy. But the judge could credit or discredit what Dr. Stewart found when he looked at the autopsy photo. There was an autopsy photo and the diagram by Dr. Hull. And whether or not there was some difference in that, in the horizontal nature of that incision.
Saying that the judge could make an independent determination as to whether or not the expert was correct?
No, but she could make a determination about whether she could credit that he had made a showing that there was some question as to the handedness of the perpetrator. But regardless of that, the other evidence on the record, my brother points to the affidavit that the defendant filed with his motion for new trial, which in this instance is a self-serving affidavit, because what's important in the record is what he told, as Justice Lang pointed out, what he told the police officers during the interrogation within 24 hours of the incident. And he said, I just can't do anything. And I would disagree with my brother in his reading of the record that it isn't with his left hand. There's
It doesn't say which hand it is,
It
though.
doesn't say which hand. And it's a audio tape, not a videotape, so we don't know where he's pointing to when he says the pain shoots up to the shoulder. But what he says is, I have medical records, and the medical records that he would have is about the operation that he had to his tendon, and not the clavicle procedure he had had 15 years earlier.
Is it clear from the record that the victim in this case was strangled and stabbed while she was in a seated position, or
No,
what
it's
do we
not.
know about the position of her body when she was strangled and then had her throat cut, and then as the police found it?
The testimony before the jury was not conclusive about what position the victim was in when she sustained these injuries. But what we have in the record before the motion judge here, who was also the trial judge, was the jailhouse confession that the defendant gave. And in that, he said that he strangled her from behind and then slit her throat.
That's Miller?
Yes, yes,
But
Your Honor.
Miller's testimony didn't go in.
It didn't come in, I agree, or, I understand that wasn't before the jury, and I did say that, but it's important to, that we can put that, the judge could consider that in context when she's determining the motion for new trial.
Except that according to the record, there's no way of knowing whether whether the victim was attacked from behind or from the front, or whether her throat was cut from behind or from the front.
Right.
So what difference does it make whether he was left-handed or right-handed?
Absolutely, Your Honor. It doesn't make any difference at all, and that's obviously our first argument here. But, if you wanted to go down the path of whether or not it made a difference, you certainly would have to look at the record evidence that the defendant, his handedness was likely the same whether he committed this crime as with his right hand or his dominant hand or with his left hand. It makes absolutely no difference, and that's likely the primary reason why with this, the one issue that was fully before Judge Fahey on the affidavits and in the record, that she determined that it didn't meet the burden that the defendant needed to in order to get an evidentiary hearing and to prevail on his motion for new trial.
I was perplexed about one argument you made, which is that if the defendant had brought up the alibi, I was gone at 11:30, then we would have called Miller.
Yes, I apologize, Your Honor. I should have.
Session which we were holding in our back pocket, and if I couldn't quite figure that out.
I apologize. It was confusing, and I apologize to the court for that. The defendant proceeded pre-trial with two theories of defense. One was about mental health, and the second was about a third-party culprit. And the third-party culprit here was fully argued in front of the judge on August 6th, and the defendant's motion for reconsideration is part of the record appendix. But it was argued on August 6th whether or not the Commonwealth had filed a motion in limine to preclude the third-party culprit. And the third-party culprit here was the father of two of the children of the victim, and whether or not he was the perpetrator of the crime. Judge Fahey granted the Commonwealth's motion unless the defendant could provide more meaningful evidence that Danny Serrano Sr. was potentially the perpetrator. Honestly, into the trial, it was unclear whether or not the defendant was going to proceed on the third-party culprit. In fact, part of Judge Fahey's ruling was that it could not be raised in the opening arguments. So it was unclear whether or not the Commonwealth would have to rebut a third-party culprit, a fully developed third-party culprit theory of the case. If the Commonwealth had to rebut a third-party culprit, which would have happened if defense counsel had exploited the inconsistencies about the timeline and the thud, then he would have called Mr. Miller to talk about the defendant's jailhouse confession. But where the case was so strong, where you had the children who spoke to immediately in the aftermath to the EMT and to the detectives about Jose hitting mommy and Jose killing mommy, that quite frankly he didn't want to muddy up the waters with a jailhouse informant if he didn't have to. And so that was part of the reason why, and I apologize, but it is also was fully explored in a hearing, which unfortunately this court does not have the transcript of. The Commonwealth doesn't have the transcript either. But the pleadings are robust, particularly because after Judge Fahey granted the Commonwealth's motion in limine, the defendant filed a motion to reconsider, which is part of the record appendix that the defendant has submitted. And there was a second hearing at the final pretrial hearing, I believe it was on August 17th, again on the same issue about the third-party culprit. And that's why likely, although trial counsel said in his affidavit he couldn't recall whether or not he had thought about those issues in particular, it's pretty clear from the record that actually he thought about them quite extensively and made a strategic choice not to go forward on the third-party culprit for fear of having that jailhouse confession and that fully detailed diagram that Mr. Miller drew of the crime scene before the jury.
So at trial, the defense was what?
It was really a reasonable doubt theory, and partly a Bowden defense. So part of it, interesting that now one of the issues on appeal is, and I'm sorry, Your Honor, and partly alibi as well. Although there wasn't an alibi instruction and a fully developed alibi defense, certainly the bulk of the defendant's closing argument was about the inconsistencies in that timeline, and he just would not have had time to do everything that the Commonwealth accused him to do. But going back to whether or not, I'm sorry, Your Honor, I lost my thought.
Okay, I've got a question for you. How solid was the evidence of the timing of the thud?
Nahima Fuller, when she testified, the downstairs neighbor, was consistent about the time between 2 and 3.
And her basis for that was what?
She said she said that she looked at the clock. She
she did.
testified that she looked at the clock. There was some grand jury testimony that was slightly different, but again, this was not before the jury. And in fact, because the defendant took the bus and went to the 7-Eleven and went to Walgreens, doesn't preclude that he could have gone back to the apartment between 2 and 3.
I seem to remember something about the neighbors on the second floor.
Yes, those were the neighbors who testified in the grand jury, Your
And so
Honor.
their timing was like Saturday night or Sunday
One
morning.
was
It much-
consistent, one was relatively consistent with Ms. Fuller's testimony, but the other was around midnight or slightly before midnight. But neither one of them testified about specifically looking at the clock like Nahima Fuller did.
Were they called? Were they on the witness list, or were they available?
They
to
were on
test-
the witness list, but they were not called.
Okay.
So if I could go back, what I lost my train of thought of, and I apologize, is about the footwear impressions. One of the interesting, when he was arguing the Bowden defense, one of the things that he said was, look, Michael Gorn came in front of you, and he can't even make a match with the sandal. So he fully exploited the fact that the footwear impression was before the jury, and that Michael Gorn was unable to say that it was a definitive match. The sandal that was found with the victim's blood in the defendant's duffel bag at his father's apartment the day after the murder, with the bloody footwear print that was photographed by just within feet of the victim's body. So certainly the argument on appeal that there should have been a Dober-Lanigan hearing is unavailing, where he exploited it, and where this court has said that it isn't necessary to have that type of hearing prior to allowing testimony about footwear impressions. And again, the jury was able to frame this testimony within the judge's instructions about how to properly consider expert testimony, which interestingly, they actually heard twice. The judge had left a little bit of the expert instruction out the first time. That was raised by the prosecutor, and the judge re-instructed fully on how to consider expert testimony. So certainly that issue is not availing.
Could you, though, given what you've said are in response to Justice Gantz's, what the defense was, comment on the request for the instruction here that counsel made?
That there should have been a manslaughter instruction? I'm sorry, Your Honor.
That he asked for a voluntary manslaughter instruction. Did he not?
He did, and there was a voluntary manslaughter
Yes,
instruction.
but the question was, I think he's challenging this on appeal.
I see. I'm sorry, Your Honor.
That it should not have been asked for because it just was, it was a last minute, there was an intruder, and that's not really compatible with, but if there wasn't, it was really only manslaughter.
Right. Well, I think the basis of the manslaughter instruction is the defendant's own statement to the police, and that he received scratches from the victim. So I think it was a borderline issue as to whether or not he actually was due the manslaughter instructions. But certainly if he hadn't gotten the manslaughter instructions, I would imagine I would be here before you saying that he should have gotten those manslaughter instructions. So, and where where the Commonwealth proved beyond a reasonable doubt that there was first-degree murder here, there's no harm. Also, when you're faced with this type of argument without any recollection from trial counsel about the discussions that he had with defendant, and without anything in defendant's affidavit about what the discussions were, if the defendant's affidavit had said, I was adamant I was not the killer, and that it had to be a defense of I was not the person who committed this horrible crime. There's nothing from defendant, and there's nothing from, except a lack of memory, which proves absolutely nothing, from trial counsel, except that he did leave no stone unturned. And with such a strong case here, it cannot be unreasonable for a defense counsel to go before the jury and say, at the very least, it's not first-degree murder. So, if there are no further questions,
Thank you, counsel.
the Commonwealth rests on its brief. Thank you.